Minister's reply, please.
Thank you very much, sir. I thank all members, although it's late in the day and we've had a day-long intensive discussion on a different bill. They chose to stay back, participate and give their valuable views. I've keenly heard them, and specifically to each one of them I'd like to give a reply without really making an elaborate presentation, because I can see that most members, in fact all the members, have really gone through the bill and the amendments and the provisions which are being made, and also the effect that these amendments are going to have. So it was very, very gratifying to hear members coming out in details about the positive impact that the amendments are going to have as regards making ease of doing business far more effective indicator of doing business in India. One thing which I'd like to highlight here is that each member raised specific issues, but broadly the concerns were about making this act a far more meaningful act, giving powers to institutions which are going to make doing business in India far simpler. I was also very impressed by the way in which members have linked to various different experiences that they've had, individual experiences, and also the collective thinking about what this country's business practices should be like. I particularly thank Member Kehkeshan Perveen for having talked about Gandhiji's trusteeship, because that was the original intent in bringing in, I suppose, the Congress party and the members here. I don't want to name the party, but then since during their era, 2013, it was when the Companies Act was first passed, had that in mind when they brought the CSR into the Companies Act, because that's the principle with which the Gandhiji's trusteeship principle with which, when profiteering, profit-making, legitimate profiteer earning through business cannot be devoid of social responsibility. And that's the principle which the original Act of 2013 contained, and the kind of amendments that we are bringing now are only to sharp focus that and make it far more effective. Because if I straight get into talking about the CSR, which I thought I'll do a bit later, but if I immediately talk about CSR, India was one of the first countries to make a legislation also speak about CSR, and making CSR as a part of social responsibility for companies was first thing done in India, and the Companies Act therefore acquired a certain halo about it, and that is what is being underlined now. Because the impact that the social CSR, which had to have on the companies, became as though you could comply or explain and get away with it. That was the interpretation which many of the companies were trying to give, not with a malified, but they could just get away with giving explanation. But this time, the amendments have made sure that we are making CSR with certain limitations, in the sense certain responsibilities tied to the larger principle. I'll explain that in a minute. So with every member speaking with a complete understanding of the impact that this is going to bring in, I was very motivated, to say the least, in responding to this debate with a greater sense of looking into the details. Sir, as you know, that 2013 is when this act was passed. It was an act passed after due consideration, after the standing committee has had a look into it, very much detail, about which most of us will always speak. There should be scrutiny, there should be detail looking into. Standing committee looked into this, and then in in August of 2013, this was passed. But even as I say that, and even as I vouch for the role of the standing committee, here's one bill which I'm sorry to have to say, here's one bill, in spite of the intense scrutiny of standing committee, is undergoing rapid changes. Yesterday I was here and I understood the sense of the House when we spoke. Insolvency and Bankruptcy Code. where we need to come up with a lot of amendments as we are learning, as we are going, because that's a very landmark of an act. But here is a Companies Act, which in spite of passing after good scrutiny by standing committee, is undergoing major changes, trying to bring in the element of ease of doing business, bringing in a robust framework with which Companies Act can be implemented. So I somehow feel that Companies Act, with a sense of responsibility, I just want to wonder and ask, was it rushed through in 2013? The number of amendments, the number of issues which we are going back on, nothing new, many of which are clarificatory, many of this is changing to make it simpler. However, it was in 2nd November 2018 that an ordinance was passed, and then by the time it was 2019 January, that ordinance had to be replaced by a bill, and in 2019, this year, in January, Lok Sabha passed this bill, but it came to Rajya Sabha, got listed 7th and 8th and 9th of January, but could not, because Rajya Sabha adjourned sine die. Today, even as I saw the honorable members of the opposition going away, my heart was really beating fast, because now I'm here trying to replace another ordinance with a bill, and ideally all of us would want to have a bill, discuss on it, and then pass it. We do not want an ordinance. Here too, thank you very much. Yes, I heard you, Mr. Gupta. Here too, when tomorrow is the date when it is lapsing, the ordinance is lapsing, and here we are trying to do our best, getting it passed in the Lok Sabha after a very invigorating discussion, and here am I sitting with 24 hours to go before when I had to clear the bill through the House. So thank you very much for all the members who have come back in spite of a long day, and you're looking at the bill with so much intensity. I'm very grateful. I'm very, very grateful for all the inputs and the sense of responsibility with which this House is conducting itself, so that an ordinance doesn't get lapsed without a bill coming into its place. So I'm very grateful. So with a broader sort of introduction, I just want to say that what we're doing now is getting all the amendments which have been notified through the ordinance. All of them are coming here as it is, with nothing added there. But we are also bringing a few more newer amendments. So a total of 12 additional amendments in 11 sections of the Companies Act of 2013 are being proposed now to be made, in addition to all that which was notified through the ordinance. Those were 29 sections, and an insertion of 2 new sections had happened. So ordinance plus newer amendments. Largely, they are aimed at to address the need to impose civil liabilities for technical and procedural defaults of minor nature. Minor nature omissions and commissions were getting compounded, severe penalties were being laid. Now we are now trying to bring the nature of minor offences to the fore, so that punishments are not severe and those can be accommodated, because they are only civil liabilities which can be imposed. We are also declogging the NCLT by shifting of routine matters out of that. So with these kind of steps, we are also again trying to rationalize and recategorize those which are with minor offences, and therefore civil defaults will be taken care of. There's a transfer of function with regard to dealing with applications for change in the financial year. I think Member Vijay Sai Reddy spoke about it. It's a very, very company-specific step, because there are several companies in India who have larger groups belonging to them, or they belong to these groups which are outside of India. And for them, when they wanted to change the financial year to keep in line with the holding company or the group companies, that provision is being allowed now, and for which we didn't want them to go through a long and circuitous waiting route. Instead, they can approach the central government, and this can be sorted out without much of a pain. Making non-maintenance of registered office. Again, an honourable member spoke about it, saying physical verification of an office is absolutely necessary. That's a very important step that we've taken. Otherwise, you knew about how within one room or even just a post office box number, several of them were operating. You never knew who actually were running these companies. So now it's become mandatory that companies do have a physical address, physical registers to be maintained so that people can go and check them so that there is a veracity with their claims. Stringent provisions are being also, with reduced timelines, are being given so that charges, modification of charges can also be accommodated. Then breach of sealing on directorship is being made a ground for disqualification. There, many of us know that there are certain number of companies for which you can play the role of a director. If those numbers are changed, if those numbers are crossed, for instance, holding of directorship beyond permissible limits. What's a permissible limit? You can be a director in 20 companies, 7 listed and not more than 10 public companies. There are sometimes people who violate it. So we want to take severe action because this leads to a lot of unstated responsibilities not being taken care of. So we have brought in this kind of a step here to bring in disqualification of people who violate that permissible limit which has been extended. So also then we are talking about CSR. I'd like to take a minute longer on that. Before I say about the CSR, one line which I want to say, I do appreciate one of the members recollecting that we had closed shell companies. Yes, 4 lakh inactive or shell companies were deregistered. Some had existed for more than 5 years, but inactive they remained. But because they were remaining somewhere, we had to deregister them. So the few related matter here as a part of this amendment is declaration before commencement of business to be restored after removing the requirements related to minimum paid up capital. Even before you start the function, it is necessary for a company to declare before commencement of business. We want to nip it in the bud that companies get registered and they stay without any function, and therefore declaration is one of the things. This is a provision which existed in the original 2013 law but got dropped, God knows why, in 2015, but now we are bringing that back. Then I told about the maintenance of registers and also making sure that physical presence is there or else they get struck off. Then, we are also insisting that in the case of a significant beneficial owner of shares, if it is not discoverable and restrictions are being placed by NCLT, we want to make sure that within 1 year, such shares would be transferred to the IEPF, which is the Investor Education Trust Fund. Holding directorship is one of the points which I've already explained, but I now move over to talking about the CSR, which seems to have attracted a lot of members' attention. It's a very interesting step that we've taken to keep the spirit of the legislative intent of the 2013 Companies Act. Actually, CSR is applicable to all those companies which have 5 crore profit or 1,000 crores in turnover or 500 crore in net worth. So CSR doesn't get applied to everybody, but you have to fall in this category. And therefore, those companies will have to state as to where they've spent the money. The earlier approach, which I had already mentioned, was, yes, we know it exists. We also have a board within the board which decides on where the money should be spent. The government has given nearly 11 to 12 item heads on which you may choose to spend. Many of the members of parliament had this worry, sir, that they're all going out of their state or they're going out of the place where this company is located. The locals don't get any benefit out of it. So what is this law doing on the company law? So all this has been constantly discussed, and it meant that we had to respond to the changes that are required to be brought in. Otherwise, people thought either they comply, it's all right, or else they comply and then give an explanation, or else they comply partly but then give an explanation and get away with it. So what we want to do is, we are giving a 3-year window, 1 plus 3 years. So if within the first year, if you have spent the 2% which has to be sent, it's fine. Or else you will move that money to an escrow account. Many of the members who spoke took the name of Prime Minister's Relief Fund. That's only an example. There is a possibility that you may, first of all, for those amounts which you've not spent, you open an account and put the money there. If you've already started spending, the unspent portion is what we are moving over. So I'll just make it clear for people who are interested in the CSR matter. We are only providing greater clarity in the provisions related to CSR, sir, by including provisions to the effect that where a company is unable to spend the earmarked amount for CSR activities within a particular financial year, it shall transfer the same to a CSR account to be spent within the next 3 financial years. So that's the 1 plus 3 window which I was talking about. So if you were unable to spend, you now get this year plus 3 years within which you have to spend. Any amount remaining unutilized in such CSR account shall thereafter be transferred to any fund specified in Schedule 7. So I have not mentioned the fund. I'm saying any fund which is mentioned in Schedule 7, you can choose to have that. So Section 135 also to be amended to provide for a specific penal provision in case of non-compliance. I mentioned earlier that it was easy for people to interpret, saying either we comply or else we give an explanation and get away with it. Now that's not happening, because Section 135 also is being amended to provide for a specific penal provision in case of non-compliance and authorize central government, the Ministry of Corporate Affairs, to give directions to the companies or any class of them for ensuring compliance with the provisions of CSR. So many members of parliament who felt that this is all in paper but never the money has come to the ground can now see that money will come to the ground. If not, it will go to Schedule 7 kind of listed accounts, so money will be available for actual spending. So that is the major amendment as regards CSR. So there's also this issue about how we are trying to strengthen the National Financial Reporting Authority, the NAFRA as we speak about it. We are providing the NAFRA with such empowerment that they can discharge their functions through its divisions, and also that a chairperson and a full-time member of the authority shall constitute the executive body of the NAFRA. Now here, in addition, clarity is also being brought in the debarment provision. There, the provision which existed earlier was a bit firm, and a lot of CAs started feeling that, it is denying them their right to their livelihood, because once they're debarred, it becomes very difficult for them to get back to all the clients who they had earlier. So the CA's debarment is being sort of diluted so that it becomes a bit reasonable, so that their livelihood is not affected. We are also bringing a bit more transparency in terms of the corporate veil, so that we really get to know who's behind any particular company and who actually is the beneficial owner who's invested in the company. There's also this question of trying to make sure that the CEOs and the key managing personnel, the KMP as we refer to them, in a company are in a fit and proper stage, or else we are constantly being referred to people who are really not doing their business properly. So like the customers in a bank, we need to know about the directors of the company and also the key operating personnel. Then we are strengthening the enforcement provisions which are available with the Serious Fraud Investigation Office, the SFIO, Section 212 will now become self-sufficient to ensure speedy and more effective enforcement, including action of disgorgement. So a lot of members have specifically spoken about issues on which I'd like to respond to them. I shall not take too much of your time, sir. I know it's late in the day. Sri Naresh Gujral had spoken about the issue of company secretaries. I remember him talking to me in this very seat, coming and telling me about how it becomes very difficult for small companies to have, by compulsion, a CS. This has been discussed. He's right, this issue has been pending for a very long time. The suggestion that is made is under consideration. Let me please inform the member, it is under consideration. We shall have to change the rules, and we can change it by the rule only. We want to do this with a bit more of stakeholder consultation, so you can expect us to come back to you on that. Sri Vijay Sai Reddy had spoken about what exactly are these shell companies. Interestingly, even in Lok Sabha, the debate centered for some time on what exactly are shell companies. Do you have a definition for them? So there's no definition for shell companies under the Act. So we are striking off companies which are not carrying out any business. Companies which are not carrying out any business for 2 years or more as per provisions of Section 248 of the Act after due process. So shell companies is a colloquial word, but in other words, in the Companies Act, the way in which we deal with what can otherwise be called a shell company is if you've remained inoperative for 2 years and with due Section 248 being applied to them following the due process, we strike them off. And also, similarly, we are taking all steps towards strengthening NCLT and the NCLAT. In fact, during the Insolvency and Bankruptcy Code debate yesterday, I went into great detail to say how we are actually providing for the NCLT and the NCLAT. Shell companies have already defined, explained as to what constitute the shell companies, so I don't think I need to elaborate on it. Which were the kind of companies which were struck off? I did quote 4 lakhs of them have been struck off. I want to explain that a bit. Section 248 of the Companies Act allows striking off of companies. Registrar of companies, when he has reasonable cause to believe that a company is not functioning, or by companies voluntarily by applying to registrar if they have nil assets and nil liabilities. Such companies get struck off, and the companies which did not file annual returns, which is what I have said to you, was used as the basis. The companies which did not file annual returns and financial statements for 2 years or more and did not apply for the dormant status. So you may not be doing business, but you didn't even apply for being dormant. If companies did not apply for being a dormant status, these were the companies which were struck off after following due process. So that's something which I wanted to explain. The annual financial year point of view, point which was raised by Vijay Sai Reddy ji has also been explained. Sir Amar Patnaik ji had mentioned that prevention of mismanagement and oppression. Why only the central government will move? Whether it is ensured that the ROCs would not harass. It was clear that one of the amendments is giving powers to the ROC, and therefore this question was legitimate to ask. The amendment pertains to identification of managerial personnel as not fit and proper. I just explained as to fit and proper is a requirement, otherwise you're just going to have people sitting and doing the function but not really engaging properly. There might be several omissions and commissions. So to avoid that, the not fit and proper assessment is made by the RC or by the NCLT after an application is moved by the central government. So the central government doesn't on its own decide that this is what it is. It moves an application, the application goes to the NCLT, and it is the NCLT which then takes a decision. After the NCLT, the application is moved by the central government. The power is given to the central government only as CG would take into account all considerations before moving this application. The intention is to debar individuals not found fit and proper. So the ROCs will have no authority to move applications to debar individuals. So they are not getting aggrandized. They are just being given that one step. They don't have an authority to debar individuals. Central government's approval is mandatory. So let that be made as a sort of assurance. So there is no question of harassment. And if any, you have a provision to approach the government to say this is what is happening and action can be taken. So there are adequate checks and balances. So Sri Narayan Das Gupta ji raised the question based on the provision in section 12(9), which have been added, would apply only when the registrar has reasonable cause to believe that company is not carrying out his business. This will not happen in every case. The reasonable cause would also be through a judicious and diligent procedure to be followed by the registrar, by the office of the registrar. The objective is to check unscrupulous practices. Again, Sri Narayan Gupta ji had raised the question of provisions in the NAFRA. I have already explained that. So there is no conflict between the jurisdiction of NAFRA and the ICAI, as their jurisdiction has been separated under the rules itself. So I think most of the questions have been answered, sir. I'm very grateful that, as I said earlier, you've given us the opportunity to take this with a sense of urgency, because tomorrow the ordinance would lapse and we cannot afford to bring it all over again. The members have participated and given their valuable inputs. I've tried answering all of them, but extremely grateful for the participation in this.
Thank you, Minister.